Father, as we're about to start your meeting, as we're about to deliberate, we ask that you'll come by here, that you'll be with us. You'll be with our thoughts, our actions, our deeds, that you'll come by here in our presence. You'll be with the technicians, that they will do the work to ensure that our meetings are more enhanced. Be with Ansard and everyone. Technical team is our prayer. In Jesus' name we pray. Amen.
Thank you, Anita. Let's begin. I'm going to ask us to go straight to the matrix, but the minutes of the last meeting were circulated, right?
I submitted up to April 7th.
All right, I would ask that we defer the minutes for the next meeting and try and get into the matrix. But what did we have another recommendation from someone to look at, Anita?
Ministry of National Security were supposed to provide information from the last meeting when they did the presentation. Mr. Richards had indicated he would attend. I'm not seeing him on us yet. I will give him a call, sir.
Remind me of information on the...
Further to the presentation they did at the last meeting on April 15th.
Who is here now? Mr. Richard not on yet.
Oh, sir. I will give him a call.
All right, we'll again go. So we'll move straight into the matrix this evening. Where did we get to on it, Anita? All right, it's out of.
Do you want me to share my screen, sir?
Yes, please. Sorry, everybody can speak from it. I have a hard copy from it. Share the screen and let us see where we can start. We go straight to the matrix this evening. Members, welcome. We'll look at future meetings. We had to postpone or we delayed meeting this evening on last time to give the domestic violence legislation some room because of the kind of some greater urgency attached to that. This is also a matter of urgency, so we hope to be able to conclude it as we proceed over the next few meetings. We'll have discussed some dates at the end of the meeting. So we'll take it up to levels on decide how many more meetings we need to get this in place. And the AG is waiting on our conclusion as well to do a number of other things. So we need to get this through very quickly. All right. That's where you have us at the right place, Anila. I can't move the screen, you know. It's McCarthy. No, I'm not.
I was saying, sir, that I have a number of documents open, so I'm trying to close them before I share.
Yeah. Get used to this virtual. I've done as much as my colleague done it. Meeting. It's new way of life, so I'll have to get used to it.
Are you able to see? Yes.
Yes, I'm seeing you. Where? Okay. Yeah. Read it from there better. And that's it now?
Yes, sir. I'm trying to make the font a little bit bigger.
Colleagues, can you read from there? Senators, Golding, Motley, can you read what this?
I'm not sure where we're going to start, sir. Are you going to start with the general recommendations, or are you starting from section 1?
The EPM, I think the format in which it was emailed may make it easier for colleagues to read if they can.
We'll start section general recommendations. But where we'll start, because that's how it's emailed out.
Okay.
We'll start the general recommendation. Right? You can cross-check with the email copy, which starts with general recommendations. Propose. Okay. There are recommendations. There's a recommendation from the JDF.
Could the print be enlarged?
It is, we are following the pattern as sent in the emails. If you have the email, it is the first item on it.
Okay, fine, fine.
Right. All right. Let's go quickly to general recommendation. AGR on. Senator Scott Motley and Senator Golding. See Attorney Donovan Williams.
I'm here.
Chair.
I'm here to,
But,
Mr. Chair.
all right, we're going to start with the matrix and begin at the very beginning. General recommendations. The JDF number 1, including the hot pursuit concept. Any that will be a required amendment to facilitate those who may have been in the zone and moved out. Is that acceptable?
Aye.
Recommendation from JSC is for strengthening of the guarantee pathway of Ministry Department Agency and Social Investment Committee. I know we can get, but we need to have the members there, which is a whole approach. So in fact, we are broadening that. So I think this would come by board. I'm not sure what the proposal, what's the amendment proposed, the legislation, but by policy. That's how we operate now. All the MDAs need to be involved to ensure that there's continuity after JSC. That also fits in with the Peace Management Initiative. I'll accept that to have an instrument to assess risk level, which means getting all the data in baseline data, monitoring mechanism, and of course the outcomes required, so that we can have some kind of a timeline of, well, some parameters on which we can base our plan to move on. Any further comments? The Richards, welcome to Ms. Miller. In my opening already can I might take it that all the general recommendations are accepted. Do we need to install CSS in legislation?
Yo. Okay.
The issue of naming family violence specifically given the level of general violence, you think that should be legislated that must remain in policy. Would you, Mr. Senator Sinclair?
I'm just trying to see what format are you going to be going through with this?
But I'm going to take that's been emailed, says easy to follow if you're not seeing reading it. And
Well,
I'm going to start the general.
I have 2 copies. I don't know. I think I printed the email and I also had gotten a copy from Parliament.
So I'm just going to take it page by page. And the first section is all the general recommendations before we go into the schedule itself.
Okay.
There are 2 pages of general recommendations.
Yes.
So at the very beginning.
Very well, I've seen it. Yeah.
Right. On the first set, I said I'm just wondering if it's necessary to, I know the importance of it, but to separate the violence is different. I mean, violence is particularly high in these communities we're referring to. And usually, generally, it's necessary to legislate family violence as opposed to keeping as a policy issue within the framework of the zones.
Minister, can I have a reference for where that comment is on the,
It's on the general recommendation at the very top. I'm on the first page.
On the first page.
Yeah, and it's the far right on the United Nations Development Program recommendation.
Okay.
I'm taking it as
I think I'm using the wrong
email
matrix because I'm not seeing that. So I'll switch. Thank you.
The front page, these general recommendations, we have the JDF. Well, each grouping, a column started with JDF through JSC, Peace Management, Police Federation, right to UNDP at the very end. UNDP made a recommendation, and I'd be advised by the legal minds.
I would have thought that that would be a policy decision,
Yes.
Minister. I can't see it being included in this legislation,
Yeah.
Frank.
In fact, most of what I see in the general recommendation seem to fit into policy more than legislation, except for if we allow hot pursuit, we'll have to do it in the legislation.
Ms. Grant has her hand up though, so maybe she wants to make an intervention.
Yes. Ms. Grant, go ahead. Thank you, Senator. Ms. Grant?
Thank you, thank you. I was just wanting to indicate that the recommendation in relation to the issue of family violence, what was recommended was that it be specified as one of the issues to be treated in the Sustainable Development Plan. So where that is set out as a requirement in section 24 of the Act, I think what they wanted was to have that issue specifically identified there.
Yeah, this is I'm concerned. Should we make it a specific item, or should we deal violence generally? Because the violence is the areas we're going into, the high violence areas where in fact the violence producers. We have to focus on those, and they in fact violate women, children, and their fellow young men. As should make it policy rather than part of a Section 24 legislation.
Chairman?
Yeah.
In respect to the issue, so sorry, there was a little bit of an audio challenge.
Welcome, welcome. Go ahead.
Thank you. Are you hearing me?
Yes, ma'am, I'm hearing you loud and clear.
Right. In respect of the issue of the hot pursuit, you may recall that consideration was given because persons may be in the zone, or they have, there is reason to suspect that they committed an offense in the zone and then go outside of it. And to that extent, it would somewhat defeat the purpose. Similarly, in the regs for the SOEs, from practical considerations, if persons commit an offense within the community, within the area, and have left, they can be prosecuted in that regard. And it's not necessarily, and that is a proper part of the policy consideration of how to deal with suspected offenders who are outside of this, but for whatever reason would have left, having done their offending, would have gone outside of it. So there has to be a connection between what is done in the zone and where they are.
So I was agreeing we could put that in the legislation section, whatever section applies, that hot pursuit will be available once you can identify that the person.
The link would have to be critical, right?
Yeah, that once it is established they have committed a crime within the zone and move out, we have the right to pursue them. Because the soldiers have the right of apprehension inside the zone, they don't have it outside. So it's got to be clearly defined. But I would support that in legislation. I'm still saying that most of the other things, the first set of general recommendations look more like policy issues than issues to be introduced into legislation. So the assessment forms, and we could make that. AD, any comments on that?
I'm sorry, DPM. I'm somehow my connectivity is a little poor.
Okay.
In and out. Please, could you please repeat?
I'm saying the issues raised in the general consideration, first column across, appears to be issues largely to do with policies that should be stated in the policy rather than instituted in the legislation or amended.
Right.
I have house pursuit, sure. Social investment fund, the MDAs, that's now national policy, but the business council is now involved in, which includes all the heads of agencies and the permanent secretaries. So I don't know if you want to make it a part of the legislation as well and give them a role.
I think there was a general consensus that the community development side of the legislation would need some review and perhaps a little reassessment of the policy to expand, having regard to the experience of the existing zone. So I'm seeing Office of National Security Advisor, that the Citizen Security Secretariat be referenced in the context of the Act as the entity responsible for coordinating and monitoring the work of the Social Intervention Committee. And it ought to be empowered to provide.
The business council was established more recently would appear to be better authority because this business council involved all the permanent secretaries. And the problem we have been having is just agencies not responding because the ministry is not giving the appropriate directions. Part of it is that the permanent secretaries feel a little bit out of the loop. And the business council, which is chaired by the Prime Minister, now has only recently established, would be the highest authority to give direction for MDAs to participate in the Social Investment Committee.
Well, Chairman, respectfully, I take a different view. When the law was designed, there was a specific reason why the persons were named at the level that they were named, and that was to enable quick decision-making without the need to have to reference back. And I find many times that it is not that the model is wrong, but it is the view taken by office holders in respect of the responsibilities that they should discharge, in these functions.
I'm with you, AG. I'm with you on that. What I'm saying, what the suggestion is here is for to ensure in the legislation that the instructions to the field workers are clear and decisive, and the CSS would not be the appropriate person to do it because they are, and other CSS is also as recent as the business council. It is who gives the PSs are the ones who have to give instruction to the field workers, and we hold them accountable if they don't give the instruction.
But respectfully, DPM, permanent secretaries would have a responsibility for persons who fall under the ministry for which they're permanent secretaries. So I don't know if legislating the giving of instructions, that's a matter of proper management and administration. Any officer who falls within the DA, department or agency, notwithstanding, the semi-autonomous nature of some of the agencies, are under the purview of the permanent secretaries of the ministry that they are a part of.
I'm with you. So it would remain a matter of policy. But the CSS is not part of the ministry. CSS is outside of it, so they have less responsibility, really. And giving instruction to the officers on the field below because the CSS is at the same level as the PS without being part of the ministry. The CSS was formed to report to the Business Council. SIC is the body that we need to keep the members attached to. That has to be a policy decision by the relevant days to ensure the SIC members attend. That's the challenge we're having, The SIC members not giving the support that they should.
We don't want to call them SIC members. The SIC.
Sure.
Yes.
SIC. Right? You may end up with a CSS. It's a lateral issue and it could be a problem. It's more important for the Business Council to be.
Well, I think we could.
It's a policy issue.
DPM, from a policy perspective, it would be to accept a recommendation of, I'm looking at it.
Social Investment Fund,
right,
as the one starts there, and then the Office of National Security.
You see, Chairman, the difficulty I'm having is that the Prime Minister names the law names the Prime Minister as the chairman of the Social Intervention Committee.
Yes.
And right.
He's also he's chairman of the Business Council as well.
Right. So if matters are at that high level, and then the co-chair, the deputy chair, who has effectively been the operationalization chair, the head of JSC, I think, from lessons learned is really the approach that is to be taken by the critical office holders. I'm totally with a recommendation in respect of the rethinking and where it's been positioned, but it's also worthwhile to look at the model that exists to see if you require quick decision making, if you require quick turnaround, and you put persons who are precisely in positions to sow the tide, and then they relegate.
Well, what I'm saying is, Adrian, is that there's literally a new model that has to work with this zone, the special operation law. The Business Council and the Business Council is completely new, and so the CSS, which now is seeking to us, have a responsibility in terms of all areas of social investment, including the zones. The Business Council is a creation to ensure that MDAs participate more meaningfully in the operations. What we're having is that JSC was on their own, literally, and all the other agencies were operating in silos. CSJP, along with JSF and a number of others, were operating in silos. The Business Council is a new concept, and the CSS reports to the Business Council.
So would you be legislating the Business Council in law under this?
Well, it could be a positive, because the Prime Minister chairs the Business Council with all the places now, so everybody knows what's happening and what the agent should be doing and can be held accountable. I don't know if we want to refer to it or we should just let it be the policy situation.
Well, we can't refer to it if it doesn't exist in law. We really would be creating.
Right.
Could we give some consideration? Perhaps we could defer a finalization of this recommendation, and we.
Yeah, but the board recommendation that I took it in, it is, JSF is saying accountability mechanism are to be strengthened to guarantee participation by the MDAs, which is really the big issue on the Social Intervention Committee. National Security was saying that it's recommended that CSS be referenced, which is not in law either, because the CSS reports to the Business Council, which is what I'm referring to. All right, we could differ that aspect, but what we do agree that there needs to be a strengthening of the process to ensure the social intervention committee is held accountable for the intervention activities. The reason I'm going to with the Business Council is that part of what was happening all along is that the agencies were kind of leaving everything to JSC or other agencies. And the Business Council is designed to correct that problem now, that all ministries must take responsibility and will be held accountable for any failings from education to social security and others, which have to continue the program even after the security side. In the whole section, they have to be there all along. And the bill section is continuing. There's no stopping of that aspect of it.
Chair.
All right.
Chair, may I make an intervention? I notice you're not seeing the hands up.
Yeah, I'm just seeing I'm looking at it. Thank you.
Earlier, I had made a comment that I did not think that we needed to take the UNDP's comment into account. But I want to reverse myself and to say that I do think it could be included in the functions of the committee at C, so that in this developing a sustainable development plan, which will include addressing issues relating to health, the environment, social improvement, and so on. We could also say at the family violence aspect of it, because I think that the violence is clearly what we're trying to address.
Right.
And sometimes it emanates from the family violence. So I wanted to.
But it starts there. I wouldn't contradict it. It's the violence starts in the family.
Yes.
Whether male or female. So
I just wanted. I had given a contrary opinion, but having reflected on it, I think it would be highly appropriate for it to be singled out as a matter to be addressed.
Okay, so I think on this first column, we would accept the hot pursuit and look at naming family violence within the sustainable development programs. We'll look again, AG, at the issue of how we introduce these new bodies in terms of the government overall policy to broaden to ensure the whole of government approach is sustained throughout all these programs, and in particular in the zones of special operations.
Yes, DPM.
We'll have to take the policy, or whether we need to put some legislative notes. So I will be advised and come back to it then.
Yes.
Right.
In respect of the policy consideration, we will note them and note the comments of the committee, and then we deliberate on where the policy issues are deliberated. Yes.
Yeah, because I know, take your note that if it's not in law, we can't name it in another subsequent legislation. And these are both major policy changes, but not embedded in law. So the next column goes again for the recommendation.
Chair.
SG, please. Yes, I see the hand here. Senator, your hand is still up, or you just take it down? Senator Scott Martin.
Sir.
SG, go ahead.
Can I go ahead? Thank you, Chair. Good afternoon to you and the members of the committee and colleagues. I just wanted clarification on the decision in relation to hot pursuit, because the recommendation is in relation to a definition, but it's not so much that you want to put in a definition. And when I look at the rationale it's not completely tied to what's in the recommendations. I just wanted to understand the decision taken by the committee in relation to hot pursuit.
The challenge really, and I'd have to maybe, is that someone may in fact commit an crime within, act of violence within the zone, and then move out of the zone. And for the JDF, they will have no authority to pursue them beyond the bounds of the zones. And they're seeking. Sure. AG, go ahead.
Yes, if I may assist you. Thank you, SG, for raising that through the lens of our chambers. Where someone is suspected of having committed an offense within the zone and has left the zone. It's to provide, to enable a member of the Joint Command to pursue that person outside of the zone for the purpose of holding them accountable in respect of the alleged offense committed inside the zone.
Okay, so AG, I think though, in terms of the actual amendment that would be made, you see, we would need to provide that for the JCF because the JCF would have that power already. So I understand then that you're saying, so really it is really only to allow then the JDF to be able to exercise the power of search and arrest that they have in the zone, to be able to exercise that power out of the zone. So the reason I'm raising, because it also speaks of the Joint Command, and I'm not sure that any power of the Joint Command, especially as it relates to the head of the JDF, would need to be exercised as it relates to hot pursuit, because hot pursuit is, as you say, is very specific.
Yes, it has to be an incident in the zone. There must be a link.
Right. Well, the pursuit could be in the moment of the fleeing, but I could foresee. Yeah, right. That's the heart of it. You know, it's on the heels. It's like the fleeing felon.
Thanks. I just needed to have clarification on the decision. Thank you.
However, SG, we may have to interrogate it a little more to see what if the hot pursuit does not end with an apprehension of the suspect,
or it gets cold.
It has to be followed up, So I suspect that is where the power of the Joint Command, power enabling the Joint Command to deal with it, may come in from practical perspective, because you can pursue, you know, hotly in the course of the flee, but it doesn't lead to an arrest, it doesn't lead to an apprehension, and you may have intelligence, but you may have to break it. It could be because of the terrain, it could be for whatever reason, and so it would no longer be hot, but it become warm or even cold, but there are reasons to pursue.
So then AG, that would no longer be, as you say, a hot pursuit. So that would be an extension to what's already in the matrix then.
Right.
Which
So
would then need further
what I'm asking
interrogation.
So whereas the JCF would be able to do that with their policing powers, it would be a matter of supplementing with a member of the JDF.
But AG, wouldn't that mean that if it goes cold, the JCF would have to take over? Although you'd be
yes.
Outside of the zone.
Yes, if it goes cold, the JCF would have to. That is why we would probably have to just see what, if any, need may arise for those circumstances. Because remember, you know, it's a link between what is allegedly committed within the zone.
It has to be a clear link.
It may be of a higher scale. It may be a number of persons. It might not just be a single suspect. It may be a gang. Who knows? So we probably could hear a little bit more DPM, but you're right. In the ordinary course of things, if it becomes cold, then the JCF would have to take over.
Yeah. See Mr. Jackson trying to come. Welcome, Mr. Jackson. I know you're out for a little while, but you come back looking fit and ready to with more zing and vim. Mr. Jackson. See your hand up. Your mic is muted.
Oh, I was saying that I won't join in the description about vigor and vitality, but I am well.
You're well and good. Welcome back, sir. Yes. Hands up.
I just want a bit of clarification. If in the ordinary course of life, if a JCF member sees somebody committing an act, is he without authority to apprehend that person, like any citizen would make a citizen arrest?
JDF doesn't have the authority. They have to act as a regular citizen. But JCF can act any time. It's JDF you're referring to here, right?
The JDF, that's what I meant, the JDF. The
and
JDF
all that, they are like any other citizen. They have no law enforcement authority.
And my understanding is that as an ordinary citizen, I can apprehend somebody and take them to the police.
JDF has the same.
Is the JDF devoid of that?
No, I would just say no. There would be, but there are some to use it in the context of what we're discussing here. Mary Chances. Remember the Indicom tried to exercise that in a number of cases. I think they lost the case. AG, you'd have to advise me, but I think that was one of the things.
I will answer you this way, that we wouldn't want to have law enforcement powers be exercised by an ordinary citizen simply because we have the citizen's right of arrest and the citizen may bring a private prosecution, which either could be taken over or terminated by the DPP. If we are, because the ZOSO is a specific law that is targeting specific operations. It's bringing together the police and the army alongside the police for specific purposes. So we really would want to clearly define the powers in the circumstances as best as we can foresee and not leave it to ordinary operations. That's how I would respond.
Yep, pretty much. All right, sir. Understood. So I think ensuring further clarification, but we would look at the hot pursuit this week. It has a bit properly defined. And so too would be naming the identification of family violence under the schedule. And the schedule. Section 24. Section 24, the schedule. Section 24, sorry. I want to define the item there. The others are policy issues we will have to examine further. The next set of general recommendations. The JDF recommendation is for penalties for those who threaten or assault members of the Joint Command Force. I think that's pretty straightforward. What section of that I want them to do? All right, JSC recommends budget for monitoring and evaluation. In the approach now being followed as policy, that is a critical part of our programs going forward. And I expect this would be a set of policy decision, and we'll have to look at that. And that's where the CSS comes in. That's their primary role, is to, once we lay out the baseline data, the baseline data, CSS is to ensure that the work being done have the required outcomes, and where they're failing, somebody will be held accountable or the program changed and the money redirected elsewhere. So it's really a policy issue, which I'm not sure how we do. AG, how would install that in the, we have to put something like that in the law. It's a necessary thing to be done. And I said the policy should be there, which again come back to the business council, that funds will be dispersed to the various agencies depending on their performance of the in the area they're supposed to be working along. But that has been monitored, not just JSF in terms of the amount of road fixed, but in terms of the number of parents interface with children in school, their performance, etc. The monitoring and evaluation is now a critical part of our government social investment program. There's a policy, I don't know if it needs to be put in the...
Sorry, DPM, I was trying to, regretfully, I just have to step out. I will,
okay, all right.
I will come back in soon. I just need to deal with something.
SG is in, and so Senator
Yes.
Scottman.
The SG is most able, yes.
And your senator's colleagues, both Senator Sharon Golding and Donald Scott, is there, so we'll take the comments.
Thank you for your kind understanding. I will come back in shortly.
The recommendation to include creating offenses for those threatening or assaulting or obstructing or hindering a member of the joint force, I think should be included. I'm not sure what section should be accepted. There's a recommendation there should be an inclusion for budget support for monitoring and evaluation. And that too is supportable. I don't know if that needs to be in legislation. It's policy. But certainly this must be noted in our report. That monitoring evaluations are crucial. That's what will determine how long we stay and how we, exit strategy. Peacekeepers in the field to monitor and maintain peace in volatile communities. Not sure. I see a name change recommended by the Social Intervention Committee, the Social Transformation Committee. It's a policy issue as well. I don't see a problem with that.
I'm very happy to hear you say that, Chair, because the term social intervention has been getting a great battering. And it's almost as if we keep it at that, we're doomed to failure from the start. So I'm very happy to see that from a policy position, you would continue, consider renaming it social transformation, because the language is important for the success.
Yes.
And certainly social intervention, we have been told that billions of dollars have been spent with absolutely no outcome. So please consider that.
No, I
renaming
like
the committee.
I'm in tune with this recommendation because again, intervention has a send a signal to that you're intervening in a place and then you come out, you don't know what to do without any objective is not embodied in that concept of it, that title. And it's like you're a stranger to the place. It's our place. Not really.
Yes,
if I may, Chair.
Sure, Fitz. Member, go ahead.
Just to enjoin Senator Motley and yourself, I do support it, welcome it. However, I would want to, my understanding is that it's not only a name change is intended, but in terms of the programs is in keeping with the name that this is changed for. In other words, because it is the aim is to transform, then the steps which are taken are in keeping with achieving those goals.
Yeah, definitely. But this is where I said we need maybe spend a session discuss the role of the Business Council and the budget for monitoring. In other words, you get into a stage where you have to lay out, you have to examine clearly to the committee what we have in terms of the data you have in there as it relates. Some place we have poor housing, others may have better housing, bad roads, then you have unemployable and unemployed, all those and school issues. You lay out the baseline data and then monitor it, which is why the budget for monitoring is important. So at the end of the time, you can see if you're making a transformative impact. It's not just intervening. You're going to change behavior, reduce the number of gangs, reduce the number of and increase number of opportunities for those people in the community. And so they were looking at it recently, and we literally need a census of all the young males from early in the community, where the zones is. And we should, within a period of the first year, engage all of them in something positive. If they are due to be in school, we get them in school. But truancy should drop by the end of the first year to 0. If they need uniforms, the PATH has money to provide that. They need to get lunch, that should be there in school. If they are 15 and over and they're not back into school, then we should get them in a training program operated by the Heart and the State. So every single individual should be positively engaged. And I emphasize the males because they are the dominant perpetrators of violence. So the transformation concept should be not only in name, but in practice. VP has asked for some defining benchmark, and that comes back to what I've just said in terms of the same name change, is getting the baseline data and then laying out specific targets to be achieved at a certain point in time. So again, but as a policy issue. Right. The next set of general recommendations include a section for exemption of members of joint force from personal liability. I would be advised by that. in the normal course of the duties of a police, in that, correct? Legal Minds, SG, you.
Chair, can you just repeat your question?
The recommendation include a section for exemption to be to the law, exemption of members of the joint force from personal liability. It is recommended that a similar provision be used in the MOCA Act, as used in the MOCA Act, be included into this act, that is no suit or order. That's the third column of general recommendations. Any comments on that from Legal Minds? Senators? Is that Senator Golden, SG coming in? Go ahead.
Well, not really then. If you, the committee members can weigh in first.
I see Senator Golding, where you're coming in. I'm not seeing a hand, I'm seeing your.
I have no difficulty with that provision. I'm actually in support of that provision.
Seems to be straightforward. I think, you know, that's normal for normal policing. That's, I think, what they're saying here. In the joint force within the zone should have all those benefits, should have that particular exemption. And we are getting a little bit more litigious, so.
Yeah,
we
the only reason I was a little hesitant, so it's not that we would have a difficulty, it's just that the Crown Proceedings Act sort of takes care of it, except, of course, if the person is on a frolic, and then, of course, you know, it doesn't apply. So we act for the JCF and the JDF by virtue of the Crown Proceedings Act. So if anything is going to go in, we would just want to make sure then that the wording, you know, is consistent with what we have with Crown Proceedings. You see, it was done for MOCA because MOCA now is not JCF or JDF. MOCA is now a stat body with body corporate powers. And so because of that, normally you would put in those extra protections, although the Public Bodies Management and Accountability Act still makes those kind of provisions to say when you are a body corporate, you know, the entity can accept liability on your behalf, but it was done specifically for a reason for MOCA because of their legal status. I'm not saying we would object to it being here, but we would just want to make sure then that it conforms with what we already have in the Crown Proceedings Act.
Thank you. I suspect the JDF was concerned that there might be a loophole that affect them and not the police. So,
but right now we represent them, you know.
Yes.
In all matters, we represent them.
Right.
Happy.
But I will take your advice on that. And they will have to change law.
DPM, may I suggest that we, on this point, we perhaps have a discussion of this matter in the National Security Council before we make a decision. Yes, thank you.
Thank you.
I'm sorry, Chair. I'm not understanding why it's such a controversial one. The fact is that personal liability isn't something that we haven't treated within the law. And I understand the SG to be saying that if there's already provision for it in the Crown Proceedings Act. I mean, certainly when there is even a matter of, say, wrongful arrest and a claimant sues the government, you know, makes a civil claim, the particular officer may be named, but it's really the government that's defending the claim. So what's controversial about this?
I share the position of Senator Golding Campbell, because that is my understanding that what is being done is to legislate the position which actually exists and is reflective of what actually takes place and is in the Crown Proceedings Act. So I wanted some clarity on why it should be concerning that it actually be in the legislation. I would think that what would be of moment is how it is worded, how it is framed, so that there's an accurate representation of what actually exists. Now, I understand the SG to be asking, is it really necessary to include it in the legislation as that protection is already given. But in light of what the AG has said, I'm now seeking some clarity as to exactly, as Senator Golden Campbell said, what is the necessity to have it further discussed in National Security Council?
I would want to ask a question. If they're asking to be exempted from any liability for any lawful act,
yes,
what liability would you have for a lawful act?
But that is the point, Senator Sinclair, that I want clarification on, whether, because as I understand it, in the Crown Proceedings Act, and generally, according to how we litigate these matters, it's only if it is proven that they're on a frolic of their own or they're acting outside of their duties that they would have to be exposed to personal liability. So what I want to know is, are we saying we do not need to include it because they're already protected? Or are we saying that we need further discussion on it because it is something new?
I am with the SG on the comments that she made, and I don't see why it needs to be included.
Yes.
I don't know what is in the mind of the AG.
No, the SG has indicated, I'm sorry, I really am having a little audio problem, so it has gone in and out. So I'm looking at the recommendation that is requested that no suit or other proceedings may be brought or instituted personally against any member of the Joint Command. So what I had heard, sorry, without having had the screen up, is whether there ought to be a change in relation to the designation of
That's it. Break it up again.
JDF, similar to the issue. Yes, Chairman, and I think that is part of the challenge that I'm facing. So,
right.
so if...
Well, the SG was saying, if I interrupt you a little bit, that it may not be necessary to bring it into law unless you'd have to have very careful wording to make sure, because that because already included in the Crown Proceedings Act.
Right.
And the AG represents the JDF in these situations.
Yes, so, and that is the position. Yes.
It doesn't really. It should not. There's no need to really include it. And if you're including it, you have to be very careful with the language. So.
Yes.
Is that the honest?
Yes. So when I made reference to the National Security Council, it is in relation to any change in policy, DPM, as you appreciate. How the policy side is determined and then brought to Parliament. Yes, it was really in that context. Thank you. But the SG has answered. Yes, and I'm
okay. Break it again. But it seems that the need
with the position she has stated. Yes.
There's not need for any change the laws in the coding.
I think that is clear. I think that is clear, Chair, and I'm not seeing it impact any policy shift either.
Yes, yeah, I share that view, Chair.
Yeah. For me, these are your comments are teaching experience, and I'm not a lawyer, learner. With the recommendations. The next time is proposed that intervention.
Sorry, I just wanted to ensure whether or not we're accepting this proposal or not for the report.
No, not necessary.
Okay.
The highest risk of the delivery of service to the highest risk of segments of the population, case management service. Certainly that's a policy issue, and that's part of the way going forward, where we require evidence, baseline data for evidence, and we measure those as we proceed to ensure that those who are at highest risk will be among the first people to receive support. Next item comes from the idea of anti-gang program in the schools, in the specific areas. That's also along the Peace and Love program. it's a policy issue, I think, as well. And certainly in the area of resolving operation, I think they would, have that kind of program. I think JSC is on board here with us, and they have been coordinating most of these things, but we'll look at bringing them some more support. Mr. Sweeney on?
These again are policy matters, though, Chair, yes?
Yeah, that's what I mean. It's a straight policy issue.
Chair, you know what might give members some comfort? If it is that these policy matters are considered and decided favorably, then perhaps the ministry would consider laying the appropriate documents in the Parliament just to solidify the policy support behind the review and deliberations that we're having here.
Give him the bark praise right now. Bark out of your belly. Bark out of your belly. Bark out of your.
No, I take that comment said the voting. I think you're correct. Once we conclude and make the necessary amendments, when we have taken on board the policy issues, we'll bring it to Parliament that you're aware that they have been adopted as policy by the government. It's the next section, Code of Conduct for the Security Forces. That seems to be another policy, but it's a no-brainer. They have to have a code of conduct. They have an established code of conduct. It should be specified in the zone where they're operating. There has been some disturbance at some point. The VPA recommendation, no, the police have adopted, the joint force have adopted the command. They have very little broad brush suppression again. They go for specific individuals. But again, it's a policy issue which needs to be reiterated, so we'll come to that. Next set agenda recommendation about policy issues, which we're going to report to NSC and we'll report back to you. The VPA recommended increased robustness in the Act. In the comments from it, I don't see any hands up. We've seen that. We should identify the larger framework for focused deterrence, which would include other criminal justice and social work actors, and not just make the management suppression only a relationship between the police, military courts, and justice of the peace. Significant policy share required, which I note, but there could be legislative requirement. I'd be advised by the law on that one. Ms. McCarthy, note that I think we accept the policy recommendation. We'll have to report on them. This one I need some further advice. SG, have you taken a look at it? Increased robustness of the Act under the VPA recommendations.
Sorry, DPM.
Senators? Yeah, go ahead.
I'm not so clear on it. I'm just reading it through. I'm not quite clear.
It's a little bit hazy, but that's my understanding. What they're trying to say here is that the legislation gives clear objectives for suppression of the security forces work and the relationship between the security and the relevant and military courts and JP. There, what they would like to see some definition of the other activities, which is also part of the crime suppression. For example, the training programs for those at risk youths who are like the John Gang, which I call the recruitable members of the community. So you may want to look at it again. There's some major policy issue, but it may need some in the zones of special operation where you want to do extra special engagements. It may require some legal direction. But again, I'd be advised on that one.
DPM, perhaps it would mean some amendment to Part 5 that deals with the Social Intervention Committee, because admittedly, there is not much in the Act that deals with those aspects of matters, which is the Act is more geared in a way towards the security aspect and not the other aspects. So Part 5 is a little limited. So perhaps, I mean, you have the functions of the committees. So I think that is perhaps where this issue would be addressed, if it's going to be addressed in the Act.
All right. Well, I notice again, we maybe need to explore it a little bit more. I don't know if any of the other legal minds have an opinion. I do think there might be something be done, and that's the section we already are putting it, just to name the role of a number of the other agencies who tend to, I said, up to now they have been staying back. The shift to the Business Council for coordination should prevent that. So there's a policy shift that should help. But maybe a value to put it in the zone of special operation to ensure we do have the required support in the other areas that is required to ensure success. As we adopt the term transformation, because several government agencies have to get deeply involved, and they've been a little bit, not reluctant, but they have not been engaged as they ought to be. So maybe a value to put it under there. If you read further in their VPA community communication.
Sir Chairman.
Yeah, go ahead.
I know I have missed a couple of presentations, so I don't know if this is one that I missed, but just reading the recommendation under the VPA.
Yes,
which is the one that you just made reference to. Is it, and where it asks for, or it suggests that the rationale is that there's a limitation in the Act, as it does not outline details of what specific tools or methods will be utilized with suppression, interruption, and prevention. And I think that from my interpretation of what is written there, I don't know if I'm correct. As I said, I missed a couple of the presentations. Is it that they are asking for something to be set out in the framework, in the legislation, that would have persons who may be classified in the, or persons who may get attracted to gangs, what the persons generally refer to as unattached youths, persons that are not involved in some way, in some legitimate activity, that they can be placed under some, I spoke with you in another place. The term control orders came up, whereby you can have legislation that deals with persons and ensure that they are attached to some of the agencies that can provide real social transformation for them.
That could be
I don't know if that is what it is, what they are trying to get at. because
You read it down to the end, Senator.
this ZOSO legislation, it seems to be putting a lot of emphasis on the suppression, the use of the military, the courts, etc.
If you go to the end of the recommendation, you'll see get a better direction. As I said, we may need to include it. Communication should include targeted interaction with the schools, sports teams, youth clubs, and other space in which children and youth together. In other words, there should be something specific to deal to ensure that the non-suppressive activities are carried out by the agencies that are to do so. That is, whether it is SDC or education, to ensure that there is change in those spaces as well. While the zones are special operational. In other words, you fix a school, but you should have a curriculum that keeps the people occupied, the students occupied. Change it though, as you could read down the recommended BPs. So you may need to include, and it could include, as far as having a control order for someone to attend the hard training facility. You're in Falcon, and you have a young man who is 18. They're going to say, look, you need to attend the Caribbean Military Academy for the next 6 months. You learn to drive, both private drive license, general drive license, operate trucks, etc. But you'll attend this and you'll monitor them on a daily basis till you see the agent behavior. So it's that kind of activity I suspect they are looking at. And they might need to put some kind of order in the system, in the legislation. I'm not sure how to do it. Again, I'd be advised by you, but as you suggested, the section on the social intervention, the role of the social intervention, social transformation committee could have some legal tool to seek to have this thing done by the required agencies, so that education, SDC, or Part NTA. Could be an order.
And you know, if one could relate it to a situation, and I'm just trying to figure in my mind, but where a person may find himself having committed an offense within the ZOSO, if you were to have something similar to what you have with drug courts, a person finds himself before the court, but because of his particular circumstances, he's put in a controlled environment and has to carry through to the end of a particular program, which may take about 6 months in order to remove them from the addiction that they have in the drug court. And then they get certificate, etc. They are relieved of the charge, having gone through the program. There is no, and if this is what we're looking at in respect to being transformational and not just having a person who commits an offense, may not be a major offense within the ZOSO, but commits an offense within the ZOSO, how do you get that person to follow through on with and work with the social intervention team that is in the operational under the ZOSO?
Social transformation team now. Right. SG, you want to look at it again, but I think, as I said, that my first thought was that we should have something, because the non-suppressive activities is where we are having a challenge with the agency. The policy shift we have made to bring the business council in place should correct that, but it might not be a bad thing that in the zones of special operations, we have some reference to the non-suppressive programs, which can begin with, as far as Senator Sinclair is going, where you meet a 17-year-old who is not committed a grievous crime, but is involved in activities which is not, acceptable. Or rather lock him up, you give him a control order to attend the required training program. And in the case of the driving school, he doesn't have to have a license. They go from literacy, they have to teach them basic literacy, general driver's license before you get to the special driver's license. So there is a facility, as well as to reinforce the need for the agencies to ensure these things are being done, even if the person is not coming under control order. So I think in the zones of special operation, there's a particular I think there's benefit to be derived from ensuring that there's some reference, whether in some section, that these activities are carried out.
By both sides, by the citizen and by the agency.
Yeah. SG, take a look at it again, and you can advise on the kind of the time of discussion, because I think the policy shift, we're making the policy shift, but it may be good to have some legal framework to ensure this is done. They're tied up, but we keep it open. It's McCarthy.
Okay, DPM Chairman. I would of course need some guidance on some of the policy aspects, but
yes, I appreciate that.
But to follow up on a point that Senator Sinclair made, I'm also wondering if it is that you would want a provision in here to say that I don't know, if certain offenses are committed, you would have, the court would then use different sentencing options, or some of the sentencing options that are already available under the Criminal Justice Reform Act. And I don't know if maybe there would be a way to put it in this law to say that the court should look to those sentencing options rather than just say commit someone to a custodial sentence.
Yeah, SG, the law itself doesn't specify much on non-suppressive activity. The police powers are there. So I think what Senator Sinclair and the recommendation is to look at that area. So that would be aspect of it, both to get the agencies to do what they should do by including in some level of, not only that hold them accountable, but if you put them in the body of the law that this is to be done. But also when you interact with sort of a 17 or 18-year-old who you look, have done something, but it's not that we were to lock him up for 5-6 years. But you can, it's against the law, you can put him in a program of this sort. That he attend the training program for the 6 months, get certified, and be relieved of the charges, so he doesn't end up with a record at 18 for whether I had hanging out with a gang or just smoking a spliff or something at that point in time. I'd asked to, this one, I think we should discuss it some more and report back to the team, the parliament, because I think it has some value, and it would be advised. And they say they may need some policy direction as well. Senator?
Sorry, Chair, Ms. Grant has her hand raised.
Go ahead. No.
Yes, thank you. I was just following up on what the SG had mentioned, because she made reference to the options under the Criminal Justice Reform Act, which does already give some of the alternatives that were referred to. For example, as an alternative to imprisonment, sending the person on day training and those things. So they would already apply. So it might just be a matter of reinforcing the existence of those options. I don't know if that's something that needs to be done legislatively. And then in terms of the persons who are children, there exists the options on the child diversion.
So it would be more a policy issue, Senator, and that again would have to be taught and directly the players, so to speak. So the security forces going in as part of their training to refresh their memory, so to speak. And the issue, with the issues there are many. I think if these things are not pointed out, sometimes they're not acted on. It's easier to act on the traditional sentencing programs. All right, I hear that. Thank you. So Ms. McCarthy, so again, it's a matter of reinforcing the alternative available and to use the law as required in this situation, and just get the players in there to be reminded of them so that they consent up front.
Okay.
The next recommendation is something that I think JSC does anyway, address neighborhood disorder. But we expect to be a bit more responsibility in the future. Social disorganization.
Chairman?
Yes, Lam.
I have joined. My apology. I have some technical difficulties.
You know, your name was
So
there.
I'm with you.
Didn't hear your voice. Welcome. Good to hear your voice.
Thank you. I'm with you. Yeah.
Where it goes to the legislation itself, no? Which is on, I'm following the email matrix so we can, you know, if you're not getting clear pictures online, you can have you can follow it on the email if you have them printed. First, here is short title and commencement, interpretation. There are recommendation for definition of justice of the peace in section 2. And they'll ask that it be removed. I didn't quite understand it. What's the legal mind of this though?
So Chair,
SG, yeah.
I don't have the actual submission before me. I'm just using what's in the matrix. And we can't delete the definition because Justice of the Peace, they have powers under the Act, and this was just a definition. And I notice it's not as if they're saying that the Justice of the Peace must no longer have any power, exercisable power under the Act. It appears what they want is an amendment to the definition, because they are saying that the requirement, I guess the way it's defined, requires a JP to have lay magistrate experience, and it's proving onerous. But I don't know. The JDF would have to further explain this point. I don't understand why they have an issue with the definition, to be honest.
I suspect when the JP is defined as one who has lay magistrate experience, it is not easy to find them all the time. And therefore you leave it to the general recommendations elsewhere about JPs. As well as I'd be a bit hesitant because part of what you're trying to protect here is that when recommendations when arrangement being recommended for the police to declare for the involvement of JP, is really setting conditions of arrest or detention. And you really need someone who has a bit of a judicial view, not just in the JP.
Chair, I am supporting that your submission. I believe that the powers which they have under this legislation, they're quite awesome powers. Do remember that you cannot sit as a lay magistrate unless you have been a justice of the peace for 5 years. And so with that requirement, it is suggesting that you need a certain level of experience. It's also relevant that the Justice of the Peace Jurisdiction Act has been amended to allow persons as young as 23 to become justices of the peace. And I really think that this particular legislation requires the experience that comes with being a lay magistrate. You can determine whether somebody is arrested. You can determine whether somebody is released.
I'm inclined to retain the definition as there, because if you lose it too much, we have other areas in the law which send the message that we are strong on security, but you also want, you don't want to. I already have one who's supportive of my SOEs, but I don't want to feel like they got to slap them out of the way. It's just because it's in the area. I think a JP who has the lay magistrate associate experience would be a value. I would leave the definition as SG.
I support that as well, DPM, and I think Senator Scott Martin's commentary is extremely useful as well.
Yes, I mean, I'm not that the young is irresponsible, but anyone who is a JP for 2 years that does decide, well, I can do this and do it. You need a little bit of a judicious approach, if I put it that way. All right.
Mr. Chairman, and I think where the JDF or the persons within this zone may be having that challenge, and it would really be for them to use greater initiative and collaboration with the respective areas, is to get a list from them of all the persons who meet the requirement of the definition.
Absolutely.
And contacts and so forth. And that is where I think they may be falling down. So they have a challenge sometimes. They may require a person, but don't have the list, an entire list who meet the criteria.
So, Chairman, yes, bear in mind that the lay magistrates are a subset of the justices of the peace. And these are persons who are specifically trained to exercise jurisdiction in the petty sessions jurisdiction of the parish court. So that from an administrative perspective, contact would have to be made with the custos for the list of lay magistrates, who are persons, like I say, are specifically trained and are quite able at the level at which their training enables them to discharge those functions.
So we're in tune, AG. We don't want to remove the definition. The joint commanders must make contact with the customers, get a list of who's involved, and then you can rotate them. As I said, crime fighting is a responsibility of all of us. So we get them. If we have to rotate some lay magistrate through this space, then it is done.
And that's the point, Chairman. The lay magistrate need not come from the particular zone, but from the wider parish. So that
the principle we don't want to give.
If you have been
responsibility to anybody who is not, we need somebody with some experience to give this weight of responsibility. All right. In fact, if you're going to reduce it to NJP, then you might as well say the superintendent of police. I'm done. All right, so Ms. McCarthy, we are not accepting that change.
I agree with that, Sir Chairman. And you have certain lay magistrate, Sir Chair, that has a list that is published with a person in that lay magistrate. You know, I think that for the most part, it is published on the website. You know, so one can that are well trained and can conduct this task the list is normally published as well.
Okay, we move to part 3. We have a couple of recommendations from the Violence Prevention Alliance and from the Office of the Public Defender. Not much for defenders a comment. Recommendations from DPA that section 3B, C and G should be more direct with that, should have some amendments. Have we had a chance to read them, AG or SG?
Regrettably, Chairman, I have not yet. Council.
But one should be more, section 3B should be more direct regarding its purpose for gang and non-gang offenders. As it is, there can be higher reporting for firearm seizure and recovery, but not for perpetrators. Nor the object of the act is a purpose stated for the detection, capture, and incarceration of offenders. I don't recall this submission very well, but I'm just reading from it here. Seems they asked the definition of the greater identification of the perpetrators. Getting into tricky areas again, but
Minister, I think what they're seeking, it to appear to me, is uniformity in reporting. And because that's what they're really aiming at. How do we report on the zones? We report so many gun seized, so many arrests, but we have seen the difficulty of just trying to categorize the cause of arrest. After 3 years, we couldn't get information from the police and the JDF on some of these. So I think that's what they really are intending, but that much of that could be achieved by administrative arrangements.
Mr. Chairman. Mr. Chairman. Are you hearing me, Mr. Chairman?
I suspect he's just on mute, Senator Sinclair. Perhaps you can go ahead because at least the Hansard is recorded.
Okay, all right. We are looking at what is being proposed in relation to Section 3. And I think from my reading of it, I believe that what they were indicating is that some of the provisions in there seem a bit vague and not targeted. That is how I understand the matrix, what is contained in the matrix, and the recommendation that is being made. At least I don't believe that they have made a specific suggestion for a change, but it appears that they are asking us to tighten up on what the objects of this particular legislation is. I don't know if it has to, as they have suggested, actually refer to gangs and capturing of offenders and so forth, because in C it says conduct law enforcement activities to rid a zone of illegal weapons, ammunitions, and other contraband. I suppose it could also state something else, but that is what I believe that they are getting at. First, to make some adjustment to what is contained in Section 3 as the objects of the legislation, and to be more specific in that regard.
EPM Chang, you with us?
It seems as if the minister got bumped off. I'm in contact with the office to see what's happening. I'm not sure if somebody else wants to take over until he returns. We could nominate a member to chair in the interim.
I suppose Senator Samuda would be the most appropriate person coming from the ministry.
That's why I'm not so sure my colleague Senator, but I suppose I will press on until rejoins us. But
we can go slowly, Senator Samuda. We can go slowly.
As long as we go together.
Minister Samuda.
Yes.
We can go through the what is contained in the objects of the act. The objects of the act are to empower the Prime Minister and to see whether, and it goes through from A to G. So we can see whether there should be any amendment, if there is any need for it to be tightened up or be made more specific, as I believe that is what they seem to be suggesting to me from my reading of what is contained in the matrix.
And certainly, Senator Samuda, at B, I think they wanted some expansion, because remember, it reads that you must uphold the rule of law while protecting the fundamental rights and freedoms of persons who reside or conduct lawful business in a zone. So I think that that is it's a general lofty position to take. But I think what they're asking for is that the objects be more detailed in terms of, what it is that we're really trying to do. And if you see, I don't agree with their proposal that it should be more direct regarding its purpose for gang and non-gang offenders and so on, and the reporting and recovery. But I think that perhaps we could expand it or be more specific in that B, as they have suggested.
And I think, Member Scott Mantley, that I would find favor in that space. Whereas I understand the recommendation they're making, It's not pure, though anti-gang activity triggers quite a lot of the reason for the declaration of a ZOSO. Some of the other factors, as DPM Chang would have mentioned, even the issue of attendance to school, shows that when you're going to make the intervention, it's not the interventions are not purely towards
moving
gang related. Oh, I hear DPM with us.
I can hear the voice, but I can't. I can't. The screen is not moving, but we're taking that recommendation.
I think Senator Samoud is delighted that you've returned, sir.
Absolutely.
He has a broader shoulder than me, and I think maybe Senator, you treat him very well in the Senate, so you should be quite happy to work with you.
No, Senator Scott Motley treats me quite well.
That's I know.
I can't say the same for everyone, but Senator Scott Motley treats me quite well.
Thank you, Senator.
I'm sure you're not saying anything there that.
I know he's talking about Charlie, so I'm fine with that.
You know, Senator Brown, you are the only person I believe that that does not share an S in the name. So be careful. Mind identifying yourself, is it?
Are you hearing me all right? The volume is okay. The screen is a bit different. But the recommendation there is that we should increase the time for reporting, especially when you get into the nature of the zones. It's not so much, and as we have discussed before, it's not the suppressive role of it is more to displace or detain the criminals, but the real purpose of a zone is special operations as opposed to SOE is for developmental purposes. So you need a longer reporting period so you can get things done and you can monitor and have the monitoring unit give specific recommendations on the targets you have set for all activities in there, especially on the side of the social investment programs, transformation activity. So I think
sorry, DPM, we're actually still on clause 3, the objects.
Yeah. Which are, oh, you're on 3.
We're still on 3.
Yeah, I was not. Let me get a earpiece so I can get the quality. But we won't be able to hear, Minister. We won't be able to hear. They won't? No, we won't be able to hear. Oh, yes, that's true. Follow technology, let us see if we can get a view. Okay, you hear me now. Clause 3, what were you getting on SG? Any? You hear me now?
Yes. Senator Scott Motley had there were several interventions. It seems as if I think some persons were finding favor with Senator Scott Motley's interventions as it related to perhaps making an amendment to section 3B to make it a little more specific. As it relates to the proposal by the Violence Prevention Alliance.
Object of the Act 3B, specific in terms of
what? Senator Scott Motley?
Saying
what were you suggesting?
I was saying that perhaps we could actually make it a little bit more specific so that somebody picking it up, for example, might not have to be guessing at exactly what it is we are referencing when we say uphold the rule of law while protecting the fundament, that we could get into a little bit more expressive language. I didn't support the proposal of introducing that it be more direct in terms of gangs and non-gangs of offenders. I wasn't embracing that particular suggestion, but I was also feeling that we could break this down a little bit more so that somebody picking it up could focus on exactly what it is what we were trying to achieve by this object. I don't know. I don't have a recommendation for how it would be done. Perhaps we could seek some guidance as to whether or not it would benefit from more specificity.
Good afternoon.
There's a specific proposal. Sorry, go ahead.
Oh,
I yield.
this is Nadine, Nadine Wilkins, Legal Reform Department.
Welcome, Ms. Wilkins.
Thank you. I've been listening. It's just that I feel very strongly that 3B needs to remain as it is. You could consider adding, but I would strongly recommend that 3B remain as it is. It is a general provision which is important in my view because it sets the tone, the whole context of everything that is to take place under the ZOSO. So if upholding the rule of law is necessary, there are a whole body of laws and they will be looking at, we have anti-gang, we have lot of scam, all of the range of laws that we have. And at the end of the day, if you were to capture in a sentence what the purpose of the ZOSO is, I think 3B would be it.
I agree with you, Ms. Wilkins, and I can't see how under objects that you can become more specific than what I see there, with possibly the only exception being in C, that it could be expanded a little bit, but we haven't gotten to C as yet.
Chairman, on page 6 of the matrix, there is a specific proposal on the Violence Prevention Alliance. In section 3B, the language could be more inclusionary and should change to be more citizen-centered and should say instead, so this is their proposal, fundamental rights and freedoms.
On again. Yeah, what I'm meant to get disrupted.
He was reading.
Citizens reside in work within Plan Secure Jamaica and center other important right based on citizen charter approaches. So that's giving a specific recommendation, and I think we should either support or not, because I'm hearing Senator Sinclair, I'm hearing Ms. Wilkins, I'm hearing Senator Scott Martin say maybe we could add. Is this something we could add?
Well, Senator Brown, it seems to me that what they are proposing is taking the words straight out of Vision 2030, right? But it is already contained within what is how B is written, because it speaks of the persons who reside or conduct their lawful business in the zone. That is very wide. What they would want us to do, what they are proposing, and I don't find it offensive if the majority agrees to amend it. No problem. It captures the wording as set out in Vision 2030 about persons working, doing business, and raising families in the zone. It sounds nice, a catchy way of describing it. Many speeches are.
It doesn't.
In that particular way.
It doesn't just sound nice, Senator Sinclair. We're talking about a transformation committee. Yes. Remember, we said we would use that word instead of intervention.
Yes.
And so it captures exactly what it is that we want for the citizenry. I think the addition would do it well.
Well, I don't think it would just be an addition, it would be an amendment. You'd
yes,
have to amend it to change the wording that is there, because the wording that is there already captures by residing, you do, I mean, that's a broad
right
term, right?
Which we have here already.
And conducting lawful business in the zone, which would include you working, doing business, and raising your family within the zone. So it would be that you'd have to actually adjust it to fit these words in, as they have suggested. As I said,
yes, because people don't think of.
I'm not opposed to it.
Right.
I'm not opposed to
people don't think of lawful business as including the other things.
Okay, I'm not opposed to it. As I said, it speaks to what is contained in Vision 2030, and most persons in the political field end their various speeches with the same words, right? I'm not against it. If everybody finds favor with it, as I've said.
If I may, though, Chair, just one small note. The suggested wording spoke of citizens. So I don't think we would want to be so restrictive and use the word citizens.
Right.
Right now, the section in the Acts talks about persons who reside or work. So I would say
I support that.
Persons rather than citizens.
Yes.
Indeed.
So I suppose CPC can
section 3B.
CPC can comment on it as to whether they are in agreement.
I don't object to the addition of the extra words there. It does no harm. And yes, I agree with the SG's observation that it should really, we should retain a reference to persons rather than citizens.
I agree. We can sign off on this one.
Chairman seemed to be out again. So we need.
No, I'm hearing you now.
Okay.
Yes. Yeah, we can sign off on that. Everybody seems to be in agreement. I think the change. The next.
Similar wording.
Continue down. That was 3B and the continue down line. That's next. Move the screen up now. We get the next one. All right. You have continue down. You have discussed 3B already. 3B continues all the way down. You need to go to the next. All right, section.
But sorry, Chair, before you get to 3G, at the beginning, the Violence Prevention Alliance spoke of 3B, 3C, and 3G. So I think the committee should just, again, quickly look at 3C, and I know Senator Sinclair had a comment there before you get to 3G.
In respect to 3C, in respect to 3C, what I was looking at is that it speaks to illegal weapons, ammunition, and other contraband. It does not refer to the offenders, which I believe that is where they are offenders, individuals, persons who may be committing various offenses. It speaks to basically objects.
As Senator Sinclair, would we be addressing it if we said to deal with illegal activities as well, rather than addressing the person directly?
Yes.
The activity, illegal activities.
Yes, I agree with that.
You don't want to name names at this level.
Right, we wouldn't be naming names. So conduct law enforcement activities to rid the zone of all illegal weapons, ammunition, and other contraband, and illegal activities or something to that effect.
Or something like that, yes.
Yes.
And to end, you could say, and to end or to reduce illegal activities.
Turn down signals back.
Leave the meeting on.
Oh man, let's turn it off. Want it back on? No, if I got feedback for the meeting, no man. Let's turn on silence. Turn off the mic. Okay. Read the video. Okay. You turn down. Okay. All right. But I'm not hearing anything now.
The video is on here.
No, the video is not the problem today.
We're hearing you, DPM.
Okay. I'm hearing you now. All right. So we accept changes in 3B.
Yes,
Recommendation.
Chairman.
Continue down the screen now.
And we had, it was proposed that 3C be amended by adding at the end after contraband and illegal activities.
Right.
Was that correct, Senator Scott Manley?
Yeah, we agreed to that because we didn't want the names.
Yeah.
But maybe
I don't have your concern, Senator Brown, because we don't know what the activities were.
we should add it at the beginning.
Yes. If I may, Chair, I would agree. It would be tidier maybe to refer to rid a zone of all illegal activities, weapons, ammunition, and other contraband.
Very well, madam.
Yes, Chair, I agree.
Okay. What about the next section, developments? It was 3B, 3G, and another section, the section below that. Plan does not the development plan. The sensibility with more the policy of monitoring and evaluation. What do you want to change? They want to change sustainable development plan.
Were they wanting to change it already? Looking at, trying to
change sustainable plan, development plan.
We're trying to define what is meant by sustainable development plan. Is it a term of art?
That's a minor term. I don't have a problem with keeping it as it is.
If I may, though, Chair, the term is used in section 24, where the committee has a specific function to develop the sustainable development plan. So if there should be any change, I would suggest that it shouldn't be in the objects provision, but it would be in section 24.
Yeah. Oh, no, I don't really see the need to change sustainable development. Sustainable is so
maybe not so much change. They're saying it's vague, so I don't know if maybe when you get to section 24, there could be some more filling out of the concept of the sustainable development plan. But in any case, my point though is just that I don't think it should be addressed in section 3.
I agree. I agree with you.
So we take the amendments proposed for 3B and 3G and we avoid this one. Okay?
And 3C, and 3C.
Yeah, 3C. GNC, sorry. G. Okay, next page we get to, as was section 4, declaration. Still in earshot, that's where I lost it last time. This one will deal with the reporting time frame. We have discussed it quite extensively in committee. In the comments, I think the recommendation from the police has more clarity. It says 6 months in the first instance with the 180 days, and then 120 days after that, and not 60 days. Because it gives you time to achieve some measurable objectives, especially during the time of the hold and build phase. And to ensure the monitoring committee should of course be, the monitoring parameters should be clearly established. Yeah, go ahead, Senator Sinclair, you're saying?
Well, based on what we have seen with the ZOSOs that we have had so far, one has gone about a significant period of time.
Long time.
Salem,
Mount Salem is gone on.
about 3
years.
Yes.
3 years.
The other areas seem to be following suit. So to extend the period to beyond 60 days, I can't see it as being unreasonable. And if it is that, as Senator Scott McLeod had said, that we should be looking on, and I think Member Jackson, in the definition or the use of the word transformational,
is a recommendation.
Going to take some time to do transformation in many of the communities that would need ZOSOs. So to extend it, I don't have a challenge to extending the time.
I want to join with Senator Sinclair on that. I agree that the time should be extended. I recall on the first discussion we had when JSC said that it actually takes them 6 years to really be transformational. I think that extending the time does still make sure that you have an element of accountability, but I do think it is more practical in terms of what needs to be done in the zones.
I'm not just going to recommend 1 year. I think in the first instance, you don't have to go that far.
I agree with
that.
us.
I didn't know the proposal was for a year. I thought it was for a shorter period.
The police recommendation is for 6 months, 180 days in the first instance, and then 150 days after that.
I thought that's what we were considering, the
I'm just
180
saying,
days.
if you look over the next, right there, national security one, national security advisory security. We'll look at the 1 year.
No, I think 6 months, especially the fact that they have certain other things that are.
No, 6 months I think is good.
Reasonable.
Yes.
And it's a law that we should keep because of the developmental phase is certainly very positive, and nobody, that's what we want going. But you still have certain restrictive aspects of the law.
Absolutely.
So
yes.
you keep monitoring, and if you need to change, you change.
That is good.
But you should be kept accountable. So it's 6 months first, and then there's 120 days after. And this, after that, it will be 2 months. Unless you want to make it 4 months.
I know the qualifying statement of not exceeding. So we're going to keep those words.
Right. Got you. What was the JDF recommendation about the? Yeah, same thing. What about this 4.2? That the condition be disjunctive rather than conjunctive.
I think in committee,
we did agree to
and I still hold my position.
What was that, Senator Brown?
In the committee, I had said no, I didn't support that because we asked the people to give up certain rights. And
I think the police comment was I think the police recommendations had more clarity. It says you should not use high levels of violence and escalating violence. The two things should be the same. It should be R. So I don't know if that in that case a little bit different.
We have to propose high level of violence as opposed to escalating.
Yeah. That's the police. That recommendation a bit different, Senator. I think that could work. It says high levels of violence rather than escalating violence. In other words, you could go in a zone which is known to have a chronic high level of violence without significant gang activity at the time. But this is a more escalating will be required for other matters, but for ZOSO, high levels of violence would be a more appropriate term, really. But I agree with you on the other side. I wouldn't disturb the other proposal for disjunctive and conjunctive.
So there was also another proposal from ZOSO, which was sent and just for an amendment to the whole 42 is expressed, but the members will have seen that submission from JSC. From our side,
the threat rule of law and public order in this way. So that's established in the What was the change?
So they want it to be separated.
A threat to the rule of law.
Right,
And
so
it's the same proposal that it should be disjunctive rather than conjunctive.
No, it's not that one. So it's slightly different. The whole every is for it so that it to have the service referred to subsection 1 are that the reasonable grounds to leave. So due to rampant criminality, so they want to be expressed as it is in italics there.
Oh, expressed in italics?
No, as it is written there.
But I don't know what's the change.
So
I see what you're saying.
I'm not sure if it's best that I read it because
yes,
of the in the showing on the screen. So what JCF is recommending is that 4.2 now read, the circumstances referred to in subsection 1 are that there are reasonable grounds to believe that due to A, rampant criminality such as gang warfare and high levels of or escalating violence and murder, and B, the threat to the rule of law and public order, it is necessary so to do.
There's high level of violence or escalating violence.
Yes.
Okay. That I think we can accept. But we'll leave the other one. Senator, you accept your proposal not to be disjunctive. All right.
Am I understanding that through your chair? Am I understand that is a proposal now to put two elements?
It's the wording of it is different. It's just, let's say there that rampant criminality such as gang warfare, high levels of violence or escalating violence.
So you're inserting high level.
If I may though, sorry, Senator Brown, but if I may, Chair, it's clear that the JDF has a different proposal from the JCF.
Yes, that's
perhaps. Right, so perhaps the committee could just consider them separately because the JDF wants all the elements to be considered by themselves and that they could, by themselves, constitute the initiation of a ZOSO, whereas the JCF is saying they would still remain conjunctive, but they just want to change some of the wording to include high levels of violence and not just escalating violence, because they have also used the word "and" in the JCF's proposal.
No, high levels of violence or high levels of violence or escalating.
Right, or escalating, right. But what the JDF is saying is that whatever the elements are, they should be disjunctive, but that's not what the JCF has said.
No, I think the committee had not supported the JDF overall. There was some debate in the committee on the disjunctive versus the conjunctive. But the JCF is just making it plain that in the issue of violence, it can be, if it's escalating, yes, you move in immediately, or it's the area that continues to have high levels, you may move in even when there is not. Once that era of chronic high violence, you can move in at a time of your choosing, which I think makes sense. The JCF proposal, I think I would work with.
This is Nanita again from Legal Reform. What the phrase rampant criminality? The phrase rampant criminality conveys a high level.
Well,
I don't know. High level of
very colorful. It's very colorful legal law would be used here now, Ms. Wilkins. Rampant criminality, gang warfare.
Rampant criminality doesn't necessarily mean that it's violent.
Right.
So
that's right. It doesn't necessarily mean violence. It could mean robbery and breaking and.
Okay.
But that's violent. Well, okay. All right. Maybe my interpretation of okay.
Yeah.
No problem.
I think the police proposal should be accepted. I think the police proposal should be accepted. You know, most of what it says are. It is high levels of violence or escalating violence or heavy gang dominance versus gang warfare.
All of those are rampant criminality.
Well, no, criminality is a little bit different.
Minister, time to see the new proposal on paper before I send to it.
Check your email, so, and we'll confirm them, right? But that's how it's written. So I'll ask you if you don't want us to delay your decision. Take a look at
What I'm suggesting is that we could move on to other. We may come back to, we may revert to this. I just want a little bit more time to be clear on the line.
Senator Brown, the only thing that I think is suggested that is a little different from what you would have said is where they have, or ADF is suggesting that where you have escalating violence, you have high violence or escalating violence. That is as one. But the others are going to be, all of them are conjunctive and not disjunctive. And I think that is where you had an issue, that it should not be disjunctive, which is what the JDF was proposing, but it does not seem as if the majority of members on this committee is supporting the JDF's position.
Chairman?
Go ahead.
Just to say that, again, from the working experience, it makes good sense to have the criteria split out disjunctively. And the recommendation of the JDF is supported by me. I don't know necessarily that any harm is done. It's really more to ensure that the law is complied with strictly, you know, the letter of the law. But I think the intent was the same thing.
So you support the JCF recommendation, not the JDF?
Yes, yes.
Right.
The JCF, yes.
Right. Okay. Yeah, I think Senator Brown, I think can be asserted. They don't kind of sliding in a conjunctive, a disjunctive activity there. It's still conjunctive, but it has to be specific, as the AG said. It's more clearly stated. In fact, the Violence Prevention Alliance, so it's a little bit different from the legal source. It was such a different activity. They wanted one word, rampant criminality, and that's it.
Well,
but I agree with AG.
Chair, if I may, I just want clarity because from what was read of the JCF recommendation, which appears to me to be quite similar, well, it seemed to, from what was read, to have favored just keeping the term rampant criminality with the others that were listed being used as examples of rampant criminality, and then to make that conjunctive with the threat to the rule of law. So that the provision would read something like, due to A, rampant criminality such as murder, gang warfare, high or escalating levels of violence, and B, the threat to the rule of law and public order. Is that what is being accepted?
Well, they interpret, that's what being accepted, but as you're interpreted a little bit different. From the layperson here. That is what we're proposing to accept, CB.
All right, Chair, thanks.
So that covers the 4 declaration of the zone. And some examples are given in the same matrix of communities named where gang dominance is, and you may not have the kind of activity alluded to before, Senator Brown. Declaration of the zone, still, section 4. Recommended that there be an amendment of section 4.5 to change the reference to Joint Command to Commissioner of Police and Chief of Defense Staff. AG, is there any comments on that? is that the recommendation is really not the Joint Command, but the Commissioner of Police and the Chief of Staff. It's a recommendation to the Prime Minister and should therefore come from that level.
Yes, Chairman.
Yeah. Seems pretty straightforward.
And again, it is for administrative workability of the arrangements. The recommendation has my support. It would be a simple amendment that would be effected.
Yeah, I think it makes sense. And in terms of the execution of the law. Extension period again. Same proposal to ensure the recommendations come from the Commissioner of Police and Chief of Defense Staff. Oh, section 5.
Isn't no, before I get to say, isn't Giant Command something that runs through the law?
Yeah, but Giant Command is the Colonel and Superintendent of Police in the year. That's a Giant Command. It recommended that the Commissioner and Chief, be the persons advising the government. So the Giant Command reports to the Commissioner and to the serious. In fact, there's a little bit of a protocol there for the Joint Command to be advised the Prime Minister. Is a little bit out of line with the command structure.
Agreed, Mr. Chairman. Agreed with that.
Yeah. So section 5 extension period. Recommendation section 5 is being recommended that Constable the Commissioner seem to be the same thing again. Time period. Okay. We can move on. Nothing new there. We go all the way now to.
Sorry, what, Chair, do you
Yeah, no, some more things. Yes.
Sorry, do you mind if on the same section 5, so the recommendations, well, from the JCF are in relation to extending the time where the orders would be, the period for the order, they want it extended from 60 days.
Yeah, but it was not covered in the first recommendation we left in section.
Well, the first one was in relation to the first declaration, but this is now the extensions. But I was going to raise something else, which I think it wasn't presented to the committee, but I think there is what I would consider a little bit of a gap in the law, because to do the extension, the law does not indicate the circumstances. So you have circumstances when you want to declare the zone, but what are the applicable circumstances when you're extending? And I raise this especially if you're thinking about what you call the build zone. So you've gone beyond the security part. So you may not have the escalating violence, you may not have the gang warfare, but you still want to continue the zone because you are in that build phase.
Well, if you recall earlier in the discussion, 8SG, we were discussing as a policy issue, stating and the possibility of putting legislation, the role of the non-security actors as well as non-security actors, as well as a different kind of custodial of judicial sentencing that people would be ordered to. And all of that will be based on some baseline data, which you'll monitor throughout. So the renewal of the base, not so much on the original call, but now on your effort in correcting some of the challenges identified in the baseline study. And if you are succeeding, then you can remove, if the systems have become integrated after 6 years, say, or 3 years, that the schools, the health clinics, the social security, the infrastructure is settled and you have achieved your targets, you may not need to renew. But if you're progressing to your targets, then you keep going until you get to where you're going. I don't know if it will be you want to place it in the section of the law in terms of the declaration. But I said this is more the developmental concept, and the transformation is what we'll be monitoring, and the need to have a very rigid monitoring and evaluation system is what the new policy direction is carrying out, and that's what we need to bear in mind in that.
Mr. Chairman.
Yeah.
I suppose it's just from a reading of Section 5, the concern that the SG has, and she has expressed it, arises because the extension is done by the Prime Minister after consultation with the where they change joint command to be the
commissioner and CDS,
right, which is a security. They are the persons in charge of the security apparatus. But you have spoken to the social intervention and how far it has reached. But that does not to say that it is excluded, but it is not stated in the legislation. So you may have gone beyond the security phase, the whole phase, the security phase.
Clear and hold, Senator.
Clear and hold.
After the clear phase, what do you do? That's basically, I think, what the SC is asking.
Yes, but
maybe.
But then when if you're going to still maintain the ZOSO and you are into the bill phase, is it that the Prime Minister is relying on the consultation that he has with the security forces?
No, can I suggest that 3G, which speaks to a sustainable development plan, is part of the objectives of this, so that the purpose is not just the security element only, and that's all the extension relates to whether or not the transformation is taking place at 3G. Right. And then at 7, the Prime Minister can undeclare such a zone. So I understand what the SG is saying, that we need conditions for it, but I think that condition is related to 3G.
No, that's correct, Senator. I said, I don't, if the law needs to be amended, because I said the chiefs are expected to take in consideration the developmental goals. It's just being done within the context of a strong security foundation. But part of their responsibility is to ensure that the sustainable transformation activity goes on. But remember, the transformation activity has to take place in an ecosystem of safety, public safety and good order.
Okay.
So they have to monitor both sides of the fence, so to speak. And once the public safety is established, they now monitor the developmental phase until they say, look, I leave it to the geographic policing, basically.
Okay, so that is would have to be a policy enforced position.
Yeah, there's one thing. I don't think we need to add to the legislation now.
All right. Understood that. Thank you.
Okay, we're getting on in the next set of, we get recommendation all the way down to section 8 now. A few more designation of the joint command, designation of joint command. 2 recommendations, let's see, one from VPA. It's being proposed that section 8.2.
Sorry, I'm so sorry, Chair, but I just wanted clarification on the amendment to the proposed amendment to section 5. Is it moving from 60 days to 120 or to 180? I'm not clear on which period was agreed on. I see both, and I'm not. I see both in the JCF, and I'm not clear.
My impression is that the JSC was offered 180 days in the first instance, and then it's 120 days after that.
Okay.
In other words, the first instance is 180, and the subsequent reports come 120. So 6 months and then 4 months after that. So you get 3 on the other reports. which seems reasonable, I said it.
Okay, so the amendment to section 5 would be for 120 days then. Okay, thank you.
I have the law section 8, designation of joint command, a recommendation that all officers in the zone, along with it, zone should also extend to all, principle of leadership in the zone should extend to all officers. I think it is by policy, but what does the law say? It needs to be amended to reflect that. But now the police having a problem with that. Section 8.
So we're,
yeah.
I was going to read it, but maybe somebody else.
Go ahead. No, go ahead. Set it up.
Whereas zone has been, that's 8.1, whereas zone has been declared, the Prime Minister and Council shall designate a member of the JDF not below the rank of Major, nominated in writing by the Chief of Defense Staff, and a member of the Jamaica Constabulary Force not below the rank of Superintendent, nominated in writing by the Commissioner of Police, to be jointly in charge of operations within the zone. 8.2, the Joint Command and every member of the Joint Force shall be persons who, in addition...
You go on mute. We lost you there, Senator. Me or you, no, who's on mute?
To their general training as members of the JDF, and every member of the Joint Force shall be persons who, in addition to their general training as members of the JDF and the JCF, are additionally trained in human rights, the use of force, and community development initiatives.
Well, I don't. It seems to cover. I don't know if you need an amendment to that. AG, I mean, this would be more like, as I said, you want this to be very specific with the law, but you're adding ethics and accountability. I don't know if it's a big difference on human rights and.
May I just have the provision on the screen, please?
And then the UNDP speaking specifically the sexual.
DPM, can I just have the recommendation just reflected on the screen, please?
Yes.
Yeah.
That's one recommendation. You need to move the screen a little bit to get the second recommendation. Anita. This recommendation, AD, is to add to this section 8.2, training in ethics and accountability.
Well, I mean, I can't really oppose to training requirements, whether it is in the legislation that it is to go. Remember when we dealt with this first iteration, it was law reform and there were so many other issues. We can consider, but
I don't know if it's necessary to be in the. We could put
is it ethics? Yes, I don't know if it's necessary in it, but it is my hope that that is part of the standard training.
That's my understanding. I said.
Of the force. No, and it is my understanding. Yes.
All the officers, in fact, some of the policemen in Montego went for customer training as well with the TBD club. So I'm not. It may be. I think. Well, Senator Golding asked AD for revised policy document to be brought to the House. I think this could be included in there to outline the details of the training. I think these are all covered in the training activity.
So, Chairman, bear in mind that where recommendations involve a shift in policy, that will have to be considered in the policy determination forum.
Yes.
Right, and it is conceivable that in reviewing the law, there may be recommendations in respect of the policy behind the law, and so that aspect is not finalized in the Joint Select Committee, but through the cabinet process, which then becomes accountable to the Parliament for the policy choices that are made.
Yeah, that's the process.
Yes.
Thank you. Make note of all the recommendations, take it to the requisite policy unit, and it will come back to Parliament for all members to see. The UNDP recommendation.
And it was in that context, DPM, that I had referenced the National Security Council, which is the cabinet committee that deals with the security related and defense related matters. Yes.
And from there to go.
Mr. Chairman, if I may, are we speaking specifically about the UNDP recommendation on training?
That's a second recommendation I'm going to raise, Senator. We were speaking about the recommendation on the BPA, which we have just dealt with. But in the recommendation of the UNDP, it could be spoke of in the same context, except, and where the UNDP is coming from is their international experience, where in fact occupying forces have tended to get involved in, sexual exploitation. And in the UN experience, I don't know if we need to put in law, but we should note it. They're recommending.
Well, I think, Mr. Chairman, my recollection is that they were also speaking about local scenarios as well.
They're asking to be into local scenarios. I'm not aware of any major sexual abuse.
No, but I think the AG addressed it in relation to what persists now in terms of training of members of the force. So perhaps we could really just confirm that to the committee, since we did entertain them in that discussion.
The JDF in particular, the back part, there were rigid policy, both internally and externally. So, it's just that depending on what level of person involved, one takes some time. The officer can deal with a rank and file person very quickly, and it looks, but the penalty for the officers are quite severe, and therefore the process takes a little bit longer. Okay, so we take that through today among the policy committee recommendations. 8.3 is recommend that there needs to be clarity regarding what is the accountability and reporting system for the purpose of access and transparency. JSC, comment. Again, we did discuss it in the preliminary standardization of the reporting process. I think that's really what this comes down to. Senator Brown is always been strong on that.
Sorry, DPM. So the reporting, I'm so sorry. The connectivity issues are posing a challenge.
It seems to be, we had discussed earlier in the general recommendation that we need standardization of the reporting process, and these two recommendations need to come back to that in 8.3. That they should be standardized and more greater clarity exercise.
So in terms of reporting, I totally support reporting. We have to ensure that the reporting is not done in a way that becomes burdensome, both for those who are preparing the reports and those who have to digest the report. But the information ought to be clear to then enable us to get a proper insight into what is doing, what is happening, and where issues arise, so that they can be handled and responded to in a timely manner.
Are they asking that you put in place a kind of format for reporting in the legislation?
No, those administrative matters are not for legislation, primary legislation.
Remember the
DPM.
I figured that was
the duty to report can be set out in the legislation, but in terms of details as to what goes into it, you can put a broad indication. But usually, when it comes to administrative details, those are not set out in primary legislation.
No, I was saying I know that in the case of the army, have a prescribed form for some things. Would you want to have that? I'm not I'm not recommending it, but I'm just wondering if that's what they're looking at. I just said the general topics could be outlined, but the details should be taken over by the commanders. But I'd expect a standardization, AG, that what the police and the JDF reports, there should be some level of, it should be clear and it should be clear.
If we know exactly what it is that we're asking for, that would enable us to do the assessment by all means. But again, would have to hear a little more on the details, but the duty to report and the time frame within which the reporting is to be done, that can be legislated. Other than that, yeah, there's a question mark to be determined. Yes.
Duty and the time frame within the established. All right. Section 9, duty of joint command to submit report. Well, following the same line of discussion. Again, you're going through the commissioner and the chief of staff, and that's accepted. But they used to give a 10-day report, and you want that increased to 30 days.
And again, DPM, while frequency in reporting may be requested and may make sense from a certain perspective, it may also be counterproductive from another perspective. Time to have so the daily recording can take place, but time to synthesize the information, time to make the checks, time to prepare, and then time again, you know, I'm not opposed to the request for a little longer reporting period. I'm not opposed to that. Just because we want to make things administratively workable to ensure that it doesn't just become a robotic duty. And thereafter you can't, you know, it becomes so burdensome that it is not done and done properly.
I'm totally in tune with the AG, but purely from the overall point of view, you could keep, I think you could have two different timelines. You know. In the first one, 80 days, you could have a shorter timeline. I think it's more than 10 days, but a shorter timeline. When you get into the bill phase, you go into a longer timeline. But what you don't want in the clear section, I suspect what the intention of report is to ensure that you keep track of all the security, suppressive security activity. People arrested, what they charge for, what engagement there was with criminals, if any. That kind of activity, which can be reported on fairly quickly. But as you get to the build phase, you really need time to do some building. Well, I don't know what's your thinking, Adrian, and the things of the members of the committee.
There's
no 30 days short. Leave that 30 days short.
So DPM, there is a the reporting comes in to the Prime Minister. It's looked at national security,
and I'm agreeing with you.
And then it is brought to the Parliament.
Right.
Yes.
I'm agreeing. He's summarizing
Yes.
the part saying that I'm agreeing with it.
And the council meets monthly.
Right.
So the council meets monthly. So
no, I'm agreeing with you and taking the 30-day recommendation. I'm just saying whether should we do two timelines. When you're building out now and get into the second phase, you still need every month. I have no problem with it.
I see. I get you. Let me give it some.
There's no objection. I'm supportive of a 30-day, but I said you could do two numbers. But at this point, I wouldn't.
Mr. Chair.
Yeah.
Okay, you're not getting into the 2-day timeline, the separate timeline, because the legislation does not establish when you get to the bill phase.
So we stick with 30 days.
So 30 days. Right. 30 days.
1 month, monthly. Section 10, suspension of operations or change of joint command.
I'm sorry, Chair. If I may, if you could just go back to section 9.2, because in 9.1 we had substituted the reference to joint command to the Commissioner of Police or Chief of Defence Staff. But subsection 2 sets out an offence provision which refers to a member of the joint command.
Subsection.
So what is to happen in that case where the Commissioner of Police or the Chief of Defence Staff doesn't comply with subsection 1? Should this offence still apply? The disciplinary action provision still apply in the terms in which it's phrased here?
Let me get to there now. Is that the JSC or the JDF recommendation? See,
no. Mr. Chairman.
Yeah.
I don't think, because the 9.1 is requiring the joint command to report through the Commissioner of Police.
Yeah, but we're changing all of the reporting to the Commissioner in Chief instead of joint command.
Yeah, but this is not liable for disciplinary action.
Are you, but in respect to this particular situation, declaration of the zone of an area as a ZOSO and the extension is going to be done with through consultation with the Chief of Staff as well as the Commissioner of Police. 9.1 is placing a duty on the person who is on the ground.
Yeah.
But there are a report which he's going to send through the Commissioner of Police.
Yeah, but
go ahead. Go ahead.
No, go ahead, Senator.
Because it would be that individual who makes up, or the individuals who make up the joint command. They are the ones preparing this report. They are not sending the report directly to the Security Council. They are sending the report to the Chief of Staff and the Commissioner of Police, who is then going to send it to the Security.
If I read section 2 correctly, then that's suggesting that if the joint command fails, they are subject to disciplinary measures.
Right.
If they fail to apply CP, if they fail to submit their report to the chiefs, they are then subject to disciplinary action by the relevant chiefs.
Right.
That is, the police comes under the Constitution and the JDF comes under the Defense Act.
That is correct. It's not as we're not to place the potential disciplinary action against the Commissioner of Police and the Chief of Defence Staff. Just ensuring that the person who is on the ground, who should be preparing the report and submitting it to their commanding officer, that they do that in a timely fashion and are subject themselves to this. It wouldn't be the Commissioner of Police who is subject to come.
Are we on the same page now?
So is it that we're deleting subsection 2 as a
I'm asking it. My reading of subsection 2 is that the joint command, this is relates to disciplinary measures against the joint command members if they fail to report to the commissioner in section 1.
But I thought that we had made an amendment in subsection 1 to take out the reference there to joint command, or not the case. So it remains as is?
Yeah.
Yes.
All right.
It is that the joint command will make the report to the Prime Minister, not the, the chiefs will make the report to the Prime Minister.
The Joint Command is reporting to their respective
no, what you have here now,
and those officers who will be the Commissioner of Police and the Chief of Defence Staff is then going to forward that report to the Security Council. That's what 9.1 is saying. I don't think we are changing that.
All right, thank you.
I think where you may be having the conflict is because in 5, we have amended 5 and also.
No, what they're doing, if I look at this correctly, Senator CP, if you read 9.1, they're taking out the joint command through the Commissioner of Police and just straight to the Commissioner of Police and Chief of Staff. In other words, it would read, during that period that a zone is declared, the Commissioner of Police or the Joint Chief of Staff, as appropriate, shall submit a written report. And you take out the section, each member of the Joint Command.
Which in that case, subsection 2 would no longer be relevant then.
To fail to comply, the subject is liable to discern matters. Oh, I see what you mean now, Ms. Grant. In other words, it would be a command issue if they don't submit the report, but the commissioner would then deal. Yes, you're right, it would not be relevant. Yeah, well, yeah, that's what you put in. The commissioners they're in charge. The command structure. The commissioner and the police chief is reporting directly to NSC. If they don't get the report, they will have to take action against the staff.
And that's what I'm asking. Why are we thinking of changing?
But it doesn't matter. It's normal.
Because 9.1 is saying, as I read it, that during the period that a zone is declared, each member of the joint.
No, that's what that will come out. That will come out.
I'm asking, why is it coming out? Why is it coming out? That's what
oh, I see. Yeah, where it's coming out.
If you take
the structure, is the structure of it?
Just take it a step at a time. Each member of the joint command is going to be submitting a written report, right? And that report will be going through the Commissioner of Police. My understanding is that the joint command, the person who is on the ground, is sending to the Commissioner of Police or the Chief of Defense Staff. And it is from that office, Commissioner of Police, Chief of Defense, or the Chief of Defense Staff, that the report is then forwarded to National Security Council. But and then you go to 2 now, that if the member of the joint command, the person who is on the ground, fails to submit their report to their chief of staff, the chief of staff or commissioner of police, then they, the joint command person who fails to do it, would face disciplinary action either under the JCF Act.
No, JSC, Constitution or JSC.
Constitution.
Police are subject to the normal constitutional regulations.
Or the Defense Act. Isn't that how it is?
That's what it is here. Now, what I'm recommending is that you remove the joint command in section 1, because in fact, the chief of staff in particular is accountable to the Prime Minister, not the joint command. And he will report based on the report he gets from his staff. And if he doesn't get the report, he has to hold them. The command structure establishes that he will discipline them, so you don't need it in the law.
Okay.
Right?
Minister.
So once you take out each member of the joint command, because right now it's a little bit ordinary. The joint command cannot report to Security Council. So it's still the way it's structured, they should really, the commissioner should convey, they should convey the joint command report. They cannot do that.
So why can't, if we are demanding accountability, what specific legislative duty does the joint command officer, what do they have? What is, other than the commissioner of police saying, okay, ensure that you send me a report in
all the conditions they don't put in their training, which is part of the training manual that they have to carry out. If they fail to carry it out, then they're actually outside of the court. They're just whether suspended, removed, or approved.
Yes, but wouldn't you don't think that the public, the wider public, would want to be satisfied that there is a legislative duty placed on them to report, especially since this legislation is giving greater powers to members of both Jamaica Constabulary as well as Jamaica Defense Force in respect to operational activity.
Well,
Minister, I am with Senator Sinclair 100%.
What, Senator Brown?
Can you imagine that, Charlie? 100% on this.
What happened this evening, though? Yeah, that is joint command structure. Senator Brown, how did that happen to you this evening?
No, man. Senator Sinclair's on the ball on this one. I don't know if he got his job yesterday as I did, but I'm beginning to feel like who's.
Oh, that's why. That accounts for it, Senator Brown.
Senator Patrick, I depend on you to correct.
I'm concerned, Lamy.
No, I might have been called another job each time.
Chairman, although you're a medical doctor by profession, you know, your authority is limited in this circumstance.
Never come with the job, you see. Not surgery. I think that the mood of the committee that it just leave it as it is. AG, don't see a problem. It was there before and not a major problem. AGSG. When AG drops out SG here.
And the JDF, and the Defense Act, but it doesn't say the JCF Act. And maybe
in the Constitution, the JCF comes under the general laws of the country.
Yeah. All right.
That they use the Constitution, right?
All right, cool.
Police Services Commission and the general laws of the country. So they are different. Defense Act is pretty rigid on it.
Mr. Chairman, if it is that they want to tidy it up a little bit so that we are clear, but that it is, we are not getting around the command structure as has been spoken about in previous sections. But we are saying that it is the Commissioner of Police or Chief of Defense Staff that will be submitting the report to the National Security Council. We can state it, draft it, so that it is absolutely clear that that is what is happening. But I think
that's clear. It is clear there, no. It's clear.
Yes. Once it is clear to me as it is written, but if you want to make it even clear.
The only thing you could do if you want is still, and I think it will be a bit to become, I'm not a drafter, that if you take out each member of the Joint Command in the first section 1, you could then add a sentence at the end of it that the Defense Staff Chief and Commissioner is required to take disciplinary action. But that's really would be a bit superfluous in the face of the command structure. Do you understand? I would struggle. I don't have any strong feelings on it. If the committee is to say, let it
I urge leave it as it is because it is putting a duty on the Joint Command. The people on the ground to make that report to the CP and to the Chief of Defense Staff. Yeah. They're not required to do it now. I don't know, divisional officers. The ZOSO is a different thing. And it's saying you must make a report. We need to know what is happening down there.
Commissioner,
as it is.
No, the commissioner that know every month they have to make a report based on the plan they give him every year. It's 12-month plan. Each of them give a plan and they have to report on it every month. In fact, ACP have to report to the commissioner every Monday morning on their activities. All right. It doesn't do any harm as far as my SG.
They make a report, but I don't know if the report is going to be as detailed as what is expected in this, where what we are looking at is
Senator, the West is becoming a trouble spot, you know. SGAG, we move on into section 10 and leave 9 as is. CP, we'll leave it as it is. If you amend one, we'll have to do what you say.
Sorry, Chair, so no change to the submitting the written and report every 10 days?
No, the time frame is changed.
Okay, the time frame is changed. Okay.
But section 9, we're saying that we'll not trouble at the structure. Remember, the CP was pointed out that if we took out each member of the Joint Command through the Commissioner of Police or Chief of Staff, it would render section 2 unnecessary. Committee members feel let's leave it as it is. section 10. This may come to the arguments raised now during in the clear phase that the Prime Minister in Council may have the right to recommend the suspension of the zones of special operation for other reasons besides recommendation of the Chief of Staff and Commissioner of Police. Any comments, dear members? Seem to me a reasonable request, especially given the length of the zones and the shift from clear hold to build. You would hope that to become, the build phase will not need a lot of the holding phase after a time, and just normal policing will continue. And if other circumstances just suggest so, then you go to, you can remove the joint command or change the, recommend the Parliament that you remove that.
Minister, I can see why this is being advanced, but given that the basis of this legislation is the recommendations of the Chief of Staff, Defense, Commissioner of Police, I am not sure whether I'd want to remove those when it comes to.
Not remove it, it's an alternative that it exists, that you still have the chief and serious is still the primary, but they're saying that it could be amended to allow the Minister and Prime Minister to make a change for other reasons.
Yeah, but I would want to say that such other reason should get the. I don't want to give the police and the army a veto, though we have already given them that in respect to ZOSO. But I am fearful of
when in the build
what
phase,
could lead to it.
And once in the build phase.
So at least let there be consultation. If you're going to make any changes, let it be with consultation with those agencies. So at least we know that they said yeah or nay. It's a Prime Minister call, but not the Prime Minister without the consultation. I'd want that little check in it.
But quite, look, the powers that they give the security forces in these areas, and I'm Minister of National Security, are quite extensive. And they're not the kind of powers that any officer, especially the police, want to give up, even when you have a time span of reasonable quietness. And, you know, that may not be sensitive to, although we are trying to prevent that the social investment, they are very close to it. So you know how many people are trained, how many people are moved from recruitability level of the gangs, and the police is quite sensitive, is aware of it. That's not guaranteed, and will come a time, leader of the opposition could raise it in the debate. It would seem that all factors here, the police cannot operate, the community cannot operate with normal policing. And you have a debate and decide if it's worthwhile proceeding. You know, I think it's not something that can be used extensively, clearly, but the possibility should exist, I think, in this kind of operation. But I remember you have pointed out, we have abridged the rights of the citizens significantly. Right?
Minister, go back to clause 7 and see if there's any conflict there. Clause 7 says.
Oh, yeah, clause 7.
The order declaring a zone may be revoked at any time by the Prime Minister. You're saying no, is the difference suspension versus revoke?
That's what was commenting for ourselves.
Revocation is different from suspension.
Huh?
Revocation is different from suspension.
Yeah, the executive retained the right as cabinet from recommendation of council to revoke, but suspension of the operation or change of joint command is a different activity.
Suspension just means stop.
So cool. So this is a suspension power.
Yeah, you're getting into more where, if in fact, ultimately the command of the security force remain under the executive, whoever is executive, no matter which, you know. So if something is going in there that you're not satisfied and the commissioner is not prepared to, then the civil authorities will have the right to intervene, suspend and review and take action. Obviously, the consultation will be in Parliament. We have it a little bit. All right, I think we should allow it. We should follow that line. You know, for example, the UNDP issue which was raised, Senator Gordon pointed out. It may not be easy for our chief to accept without trial that there may be a level of abuse taking place in the community. If the executive feels that the level of abuse from reports justifies a suspension for review, I think we should have authority. I think that's the kind of circumstance you're talking about, that if something is emerging within the force that a chief or a commissioner may not feel comfortable accepting unless there is definite evidence, you know, not just information, but evidence to consider his best field commander have implicated himself in issues, then the Prime Minister would have, of course, through the Security Council, the right to suspend and await further reports. I don't think something will be used extensively, all right, but I think it's designed to remain that the civil authority has the ultimate control of the activity of this nature.
And so the recommendation up is something that you find favor with, Minister.
Yeah, I think it should be placed here.
And I agree with you 100% regarding the suspension. Because suspension is just going to take us right back to all the constitutional rights that a person will have under the Constitution. Yeah. So there is no danger to anyone.
No, it is, you're retained and they'll be there, you just suspend that activity.
No, what I mean is that you will be suspending the stronger powers and the powers of suppression. And yes, that you would have under the ZOSO.
Yeah.
And you would be reverting to normal
security operations.
Right.
And if
so I don't think that there's any harm in it. And that's why I support the proposed amendment. The one that has been recommended by the JSC, who is it? The JSC.
Yeah.
Yes, they have on the matrix. There's a little error on it because they have Jamaica Constabulary Force, but they put JDF. Yes. So yes.
Sorry, DPM. So the recommendation is to enable the Prime Minister to suspend it on the recommendation of the two heads.
The current law is that they recommend you needed two heads, but they're suggesting an additional amendment that the Prime Minister will have the authority to suspend without the recommendation of the commission of the heads.
If necessary, yeah.
If necessary. It's essentially a fallback position, and I guess come back to what they call residual authority in the executive. I think it's
what is the rationale for that?
There may be other reasons. There may be reasons that
I see. As Senator Sinclair has said, I mean, this is a de-escalation action, which would return things to a normal state and would put normal policing back in the space, meaning that the space would be under the jurisdiction of normal policing as opposed to these enhanced provisions. So there could be no harm, since in any event, the power is with the Prime Minister in council to take action in accordance with the law.
But he's not revoking at this point, he's just suspending.
Right, it's a suspension. And yes, I mean, there are dynamic situations that are quite plausible that would make it quite proper in appropriate circumstances for the head of government to take action in certain cases. Very well.
Let me suggest, there's a by-election in Greenwich Farm or in Augustown that gives the power, the Prime Minister could insert, whichever Prime Minister has the power then to say during the period of this election, because it's another factor, I'm suspending ZOSO. In other words, it's not just limited to those being advanced here, and that's what worries me, and why I still believe there ought to be that consultation. Oh, well, but I hear where we're going. Every good.
The SOE was lifted for the election, you know. In consultation opposition, the SOE was lifted for the time of the.
Yeah, the SOE, but the ZOSOs.
No, it's the same thing. Yeah. But the community in which we are speaking have had their rights abrogated for security reasons and developmental reasons. Any reason that the right is not necessarily security.
Yeah, but
I think,
Minister, don't take Greenwich Farm and Augustown to be the specific. I'm talking any zone.
No, man, I'm with you. Any zone at all. My position is a bit more beyond even my legal advice. I think anything of this sort, the civil authority must have the ultimate authority to act even without this, the security forces. Where democracy and the head of government must have that authority in reserve if find it necessary in response to the station. Once you have abrogated the rights of the citizens and a legal base in that community, from an administrative point of view, the civil head of government must have the right to intervene if the circumstances change and they feel any need, whether the police are here or not, or the chief of staff.
Would we be willing to lay down the conditions under which the Prime Minister may
the ultimate authority of government is the civil authority, and you cannot define all circumstances. And the civil authority must reserve that authority. There's nowhere in the country the security force must have authority, can have veto powers over the action of the elected Prime Minister. It doesn't matter who it is, whether it's one Golding or other Golding or Manley or Shear or currently Andrew Onis. I think it's looking at it from that point. That's that. I didn't go into the detail law that's being done, but looking at it now, that is something that should be there. The reserve right of the civil authority must always be there.
But Senator Brown, can you tell me a situation where you would not want
both pieces are in there?
No. Oh. Senator Brown, can you think of a situation that you would not want circumstances to return to one that is governed by all the provisions of the Constitution of Jamaica? Because the ZOSO, for example, allows for the JDF to do certain things which in normal times they wouldn't have the authority to do.
Yeah. So the authority must have
and to go and conduct searches without warrants and so forth. If the civil authority is saying let us suspend that for a moment because of whatever reason, all you'd be doing is reverting to what is protected by the Constitution of Jamaica. Which situation, wouldn't you want that to always be the position?
I hear you on that.
May I just add? Yes. Bear in mind that when we are passing laws and vesting powers, we have to consider that the powers are given to the holder of the office, and it's not limited to a current holder. So part of the assessment is whether any Prime Minister minister, whether a prime minister that comes from one side, I mean, the current side of.
You're breaking up.
My concern is not about the incumbent. My concern, yeah.
That's what I said.
Sorry, Chairman, I don't think you were hearing me.
Yeah, you broke up there, LG, and I was kind of supporting your position. You're heading in. Go ahead, though. Yeah, hear you again. We hear clearly, AG. There, you're cut off again. Senator Brown, this is why I said my position is a bit deeper than the legal position brought by the AG and the other lawyers of the team. I have a definite philosophical position. Any law that abrogates the right of any other citizen for a particular reason, for a particular amount of time, must leave the reserve right of the civil executive to intervene when he thinks the circumstances change. And I would not bear that the must be reserved. Just like the firearms authority, issuing firearms is not my responsibility. It's designed for the affiliate to issue them. But the reserve right of my minister to intervene because arms is a deadly weapon. It's there, and I use it very rarely. And no minister used to use it, and you are aware. From both sides, I've done 3 interventions in 4 years. And I do it in consultation with the chairman of the appeals committee because I think it's a reserve right that must be protected for civil authority. I don't think it should be debated.
I have no problem with that principle. I share that principle.
Yeah.
I just want to make sure, and you did your things, as you said, with consultation. I just want to make sure, and I'm thinking through what, you don't have to, but modern governance is inclusive and is transparent.
Yeah.
And so I could see scenarios where
I cannot see a scenario where you would want the civil authority not to intervene to restore the normalcy. Unless you have a prime minister who's going to encourage.
A prime minister act.
At his own discretion, as the elected head of state, that the committee should.
Hence the concern about checks and balances. Well, I'm not going to oppose it.
Yeah.
I'm not going to oppose it, but I just express that concern and to say, to ensure that whatever checks and balance would be needed, whether it's consultation or whatever, would be observed.
Yeah.
Senator Brown, if I may, Chairman, I'm not sure if you were hearing what I was saying. Right. So bear in mind that when power is vested statutorily in the holder of an office, we shouldn't think of it as being limited to the current holder. It is anyone who holds the office at any given time that will exercise the power. And also the Prime Minister is also in our arrangement of government is normally the Minister of Defense. In practice, decisions are not generally taken in isolation. So the only question is, what would be the rationale for vesting that discretion in a Prime Minister to take things down, to take it down, in other words, suspending it. And there may be other reasons impacting an area, a zone. So, but I hear the deliberations.
Yeah, but AG, obviously you haven't heard me. I've said very clearly, I'm not speaking of the incumbent.
Yes, you did.
You know what is interesting? You know what is interesting in all of this, gentlemen, ladies? The fact that it is a recommendation coming from the Jamaica Constabulary Force. It's very interesting that they are saying, don't leave the suspension to us alone, but the civil authority, elected civil authority, should have that discretion, depending on the circumstances.
We accepted that, but I take the debate from Senator Brown in good spirit. I think we need to debate these issues when we're doing it. By the records, and we know that you expect a democratic elected government to go into consultations and matters of this weight. And when they go to it's not been done in the middle of the night with nobody knowing. In fact, they maybe come to Parliament, indicate that I'm going to do something, and therefore they can be full debate. That kind of discussion is what we're expecting as civil atmosphere in the country. because it no longer clearly is not a matter of rampant violence that is the issue. It would be other issues which would require a certain level of interrogation.
Exactly.
Right? So it will be discussed widely. But that residual power to interfere and restore, I think, should be there for the civil authority, irrespective of who the Prime Minister may be.
And so,
Right.
Chair, if I may.
Yeah.
Thanks.
Go ahead, SG.
Yes. And sorry to be making this intervention on what I know must be a convenient time. But anyway, just quickly though, so Senator Brown had pointed to Section 7, where the zone can be revoked by the Prime Minister and Council. It seems as if now the committee is agreeing that it's a similar power that can be exercised in Section 10 to suspend. I'm going to ask the committee to consider, instead of the wording that has been proposed, where it says you suspend either on the written recommendation or on no written recommendation. That's basically what the recommendation is saying. It may leave the question as to when should the Prime Minister in Council act without the written recommendation. I would suggest that tidier and cleaner method would be as you have it in Section 7, where you just say that the order, the suspension can be done by the Prime Minister in Council. Because if you put it, if you leave it with both, you're going to have those questions as to did the Prime Minister in Council act appropriately or not, and there's this discussion.
Okay. Thanks for the tidying up, SG. And that's a little bit satisfied that it was done not so unilaterally, but in context of the established institution of council, where the staff is.
And then I was wondering, Chair, if it's a convenient time, if I may be so presumptuous to ask.
I was about to say it's a convenient time.
Thank you, SG. Thank you, SG. DPM, it must be a
Thank you, SG. Thank you, SG. Thank you, SG, too.
I add my thanks. Thank you, SG. I can always count on you.
I took up my notes to this that we have a couple of days for next meeting. I hope we can finish in two sessions, May 26th and May 27th. I don't like the 26th after I speak. We will send an email out. If you want any comments, so we send an email out. Look at the time. We have 2 Thursdays, the 27th and the 3rd of June. But the days have been reserved. That's why I have them on paper in Parliament. So what I do have.
I know I'm not able to make it on the 27th.
Neither am I, Chair. I can't make it on the 27th.
So like the 10th, we could try for the 10th.
Chair. Yeah. The minister that pays us has set a meeting for the 27th. And I was going to have to juggle between two. But if I don't have to juggle between two, so that they may...
Space reserved, the 26th and 27th. You want us to do just one day, the 26th or the
26th is available.
So we stay with the 26th and then maybe look at the 27th a bit differently. The 3rd of June, it's a Thursday.
Several of us won't be available for the 27th.
3rd is convenient.
Yes, we're doing the anti-gang. 26. I'll have to hold the 26. I'm gonna debate the anti-gang on the 26th AD, which is
very well. Very well. I think the members have been quite cooperative in trying to enable as soon as possible. But with so many joint selects taking place on so many important pieces of legislation, DPM, that's the challenge.
It's just 1 week. We go to June 3rd. Yes. You needed to do something. We go to June 3rd. And, all right? Because I said I do the anti-gang.
Right. Yes. Very well.
So I'd have to do that. Senator?
All right. Good. All right. So I move for the adjournment.
Adjournment accepted. Thank you. I wish you all well. Figure out who.
Thank you. Yes.
Take care. Get a little break now. Thanks for the support and stimulating discussions.
Thank you, Chair.
Thank you.
Thank you.
The National Labor Day concert is on PBCJ this Labor Day, Monday, May 24, 5 p.m. with some of Jamaica's leading gospel artists.